One of the A2J lab's truly signature studies is an evaluation of pretrial risk assessment tools, otherwise known as actuarial risk assessment tools. And these are tools that have been designed to help judges make better decisions at initial appearances about what to do with defendants who appear before them. Generally speaking, we think of the calculus that a judge goes through at initial appearance as concerning two different issues. The first is quite procedural. What is the likelihood that if we release this individual on their own recognizance or give them a low enough cash bail or bond amount so they can secure their release, what is the likelihood that they will actually come back for the next court appearance? Stated otherwise, what's the risk of failure to appear? The second issue is, of course, of great importance to society at large. What's the risk that if we let this person out or give them the means to secure their own release, they will commit new criminal activity or even new violent criminal activity upon release? One of these risk assessment tools is known as the Public Safety Assessment, or the PSA. And that is the tool that we at the Access to Justice Lab are evaluating in a number of sites around the country. And the whole idea behind this evaluation, which of course, as all A2J lab evaluations are, pursuant to a randomized control trial, is what is the effect of providing that additional scientifically validated objective information on the judge's decision-making? Because these are controversial instruments. A lot of people think that they reduce decision-making for judges to a cold, overly objective formula, and that that's not consistent with individual justice. And we take those concerns seriously, but we think that someone has to really ask, what's the alternative? Would we rather have unguided decision-making, where judges admit that they don't really have enough information to work on, or would we rather have a scientifically validated risk assessment? That's really important to us. Of additional importance is stressing that these risk assessment tools are really designed for limited purposes. So there are situations around the country where sentencing risk assessment tools have been used for pretrial decision-making or vice versa, and we really want to stress to the policy community that these risk assessment tools were designed for particular purposes. We're going to evaluate them according to those purposes, and we strongly urge them to be used for that limited purpose.
In Dane County, Wisconsin. Chris has talked a lot about kind of the promise and perils of the PSA, so I won't go too much into that, but the idea, I guess, is that, you know, if you have a risk assessment that's better able to determine who should be released and who shouldn't be released, and if that's at lower cost, if it means that you're not relying on potentially racially biased variables, then that's something that jurisdictions might want to hold on to or start to implement. But we don't really know if that works, and we have to test that to make sure that those things are actually happening, and that's where we come in.
What we're going to do is pretty simple. In a randomly selected set of cases, the judge will get the output, the report from the risk assessment tool, which lists a number of factors that go into the PSA, how the defendant scored on those factors, and then some numerical scores to help guide the judge in his or her decision-making. But the really important part about this risk assessment tool is it gives a specific recommendation that has essentially been agreed to by stakeholders in the community. And what we will do is track the outcomes of the defendants who had the PSA used at their initial appearance versus those that did not on a number of dimensions. Of course, the most two important are failure to appear and new criminal activity, but we also care about the defendants themselves and broader efficiencies in the criminal justice system. So we do care about the number of days incarcerated that defendants experience, both because it imposes costs on the criminal justice system and because the longer someone spends in jail, especially before they've been found guilty, the harder it is to maintain contacts with family, the harder it is to maintain a job, and any number of other socioeconomic considerations that we care about.
So Wisconsin is a really interesting place to launch the PSA. First, the state doesn't really have private bondsmen. So you might think that folks like defendants, you know, might show up to court more since they're putting their own money in. But at the same time, having that sort of system might mean that those defendants and their families are going to experience financial strain. So implementing the PSA is more likely to kind of have higher impact in that area, because a better calibration of who should and shouldn't get released will mean that those sort of constraints in that state will be a little bit reduced. Now, the other thing is that Wisconsin has had a lot of well-publicized kind of incidents with regard to policing and race. And this is, I think, a really interesting way to start a conversation about that. Dane County has been really good about wanting to think very carefully about racial equity.
So again, beyond the straightforward evaluation of the PSA, that specific tool, we at the lab are really excited to be a part of the larger debate, both in policy communities and in the academy, on the value of these tools, because they do hold a lot of promise for improving public safety as much as they do for innovating and creating efficiencies within the criminal justice system.